Picture this, you're arrested and the police start asking questions. Do you have to answer? Today we're busting this myth and comparing how the right to remain silent works in Australia and the United States of America. We'll explore the legal principles behind this right, exceptions or limitations, and how it differs between these two countries. I will also share practical tips tailored to Australia and the United States. Many people believe that if you're arrested, staying silent will make you look guilty or even get you into more trouble. But is that really the case? Knowing your rights can protect you from self-incrimination and ensure fair treatment under the law. In Australia, the right to remain silent is a common law principle, meaning it's not explicitly written in the Constitution but is recognised by courts and legislation. This right allows you to refuse to answer police questions, except in specific situations like providing your name and address when required by law. The Petty case in 1991 established this principle, where the High Court of Australia held that no adverse inference could be drawn against a defendant for exercising their right to remain silent when questioned by police. This decision emphasized the protection against self-incrimination, which is a cornerstone of the right to silence. The court reasoned that allowing adverse inferences to be drawn from silence would erode the right to silence and render it valueless. It would create pressure on suspects to speak when they have a right not to, potentially leading to self-incrimination or the fabrication of answers. The prosecution is also prohibited from commenting on the accused's silence during questioning in a way that suggests guilt, or that their silence weakens their defense. This right exists independently of statute, although it has been given statutory effect in some jurisdictions. While Petty case firmly established the general principle, later cases and statutory developments have introduced limited exceptions where, under specific and carefully controlled circumstances, for instance, failure to mention a fact later relied upon in defense after being given a specific caution and opportunity for legal advice, an accused's silence may be considered. In New South Wales State, under the Evidence Act 1995, adverse inferences can sometimes be drawn if you fail to mention something during questioning that you later rely on in court. However, police cannot force you to incriminate yourself, and exercising your right to silence cannot be used as evidence of guilt in most cases. Under the presumption of innocence and the prosecution's burden of proof, the accused has no obligation to assist the police in their investigation, and their silence cannot be used against them in court. In the United States, the right to remain silent is enshrined in the Fifth Amendment of the Constitution. When arrested, police must inform you of your Miranda rights, which include the right to remain silent and the right to an attorney. The case that reaffirmed Miranda rights is Dickerson v. United States in 2000. In this landmark decision, the U.S. Supreme Court upheld the principles established in Miranda v. Arizona in 1966, ruling that the Miranda decision was a constitutional rule that could not be overturned by an act of Congress. The court emphasized that the Miranda warnings are essential to protecting the Fifth Amendment right against self-incrimination. Unlike Australia, this right is constitutionally protected, and anything you say before being read your Miranda rights may not be admissible in court. However, you must explicitly invoke your right to remain silent by saying something like, "I am exercising my right to remain silent." Simply staying silent may not always protect you. Both countries aim to protect individuals from self-incrimination and ensure fair legal processes. In both systems, you can refuse to answer most questions without facing penalties. The key difference lies in how these rights are codified. In the United States, they are constitutional and require police to inform you of them. In Australia, they are based on common law, with certain statutory exceptions, and vary slightly between states. In other words, in the United States, failing to invoke or say your right clearly and directly can lead to complications, whereas in Australia, the right is generally assumed unless specific exceptions apply. Being arrested can be overwhelming, but knowing your rights is crucial, especially in Australia and the United States. Here's what you need to know. If you're arrested in Australia, you have the right to remain silent. Here are 3 key steps. First, politely ask the police if you're required to answer specific questions. Second, clearly state, "I choose to remain silent," and immediately request legal representation. Third, avoid saying anything unnecessary that might be used against you later. In the United States, the right to remain silent is part of your Miranda rights. Here's what to do. First, say, "I am exercising my right to remain silent." Second, request an attorney immediately. Don't delay this step. Third, refrain from answering any police questions until your lawyer is present. So, do you have to talk to the police if you're arrested? The answer is no. However, the specifics depend on where you are and the circumstances you're in. No matter where you are and what circumstances you're in, your words matter. Staying calm and informed can make all the difference. Knowing your rights is your best defense. If you found this video helpful, hit like, comment, and subscribe for more legal content.